So, a federal judge has rejected the Justice Department's bid to continue with its criminal investigation into the content of the classified documents seized at Mar-a-Lago. And that judge has also appointed a special master to review those documents and set a November 30th deadline to complete that review. With me now is the publisher of the blog Lawfare and former CIA officer David Priess. And David, as part of this ruling, Judge Cannon says that she doesn't accept the government's argument that, look, these were classified documents, therefore Donald Trump doesn't have any right to hold on to them. And what Judge Cannon wrote here, and I want to read this, she said, the court does not find it appropriate to accept the government's conclusion on these important and disputed issues without further review by a neutral third party. Disputed issues, which seems to suggest that she considers it a disputed issue whether these were classified documents.
And to be clear, Trump's legal team did not dispute some of those core facts. They did not assert that these were declassified or unclassified documents. So the judge essentially is creating the dispute by saying the government is asserting in the affidavit that these are classified materials. There are classified cover sheets that we've seen. We have not seen the actual documents because that's the classified information they don't want to show to the public and to our adversaries. But presumably, these are top secret, secret, and confidential documents. She is saying, I don't trust you that they're actually classified. Who do I trust? A designee of the court, a special master who's going to determine more than the executive branch, which handles classification issues, what is classified and what isn't. It's a silly ruling, and I hate to use that adjective because it actually does have an impact on intelligence collection. It has an impact on national security. But the ruling itself is just nonsensical.
I also want to note in the subpoena, the documents to go execute this search warrant, the language is marked as classified, right? In a way, legally, it doesn't matter. It only matters that they were marked as classified. I guess I don't understand why it would be disputed.
Well,
what the dispute could possibly be.
There really isn't one. I think it was an excuse to delay this process. This judge wanted to delay this process. That was clear from the very beginning. And she's looking for something to grab onto to do that. This is actually a very weak one to grab onto. It's not going to hold up on appeal if it goes to that, which I expect it will, because there's no real precedent for this. For a judge asserting that something might not be classified, I know there are lots of people who were prosecuted in cases of mishandling classified information who would love to go before a judge who did not have the defense attorneys saying these really aren't classified documents, but the judge unilaterally says, but maybe they're not classified, so let's not worry about it right now.
One thing that is interesting, in no legal document or a statement out loud in court has a representative of Donald Trump affirmatively said that Donald Trump declassified these documents. It hasn't happened in a courtroom or a document. One of the reasons why could be it carries more weight if it's actually in a document than if it's said out loud in a political setting. Donald Trump did an interview with Hugh Hewitt yesterday where he talked about this. Listen.
Mr. Patel said he witnessed you giving verbal orders to declassify the papers that ended up at Mar-a-Lago. Do you remember making those orders?
That's correct. And not only that, I think it was other people also were there. But I have the absolute right to declassify. Absolute. A president has that absolute right. And a lot of people aren't even challenging that anymore.
Well, first of all, does anyone challenge that a sitting president has a right to declassify?
No.
But that's a moot issue because we're talking about a former president here. And it's interesting. He says that Kash Patel witnessed him declassifying everything. Other people did too. But the lawyers, as I said before, they're not making that case in court, are they?
No, because they didn't execute the process. So let's say, hypothetically, that the president, in the presence of Kash Patel and a few other people, did say, I want to declassify everything. Great. He can say that. But if nobody executed that, if nobody told the agency originating the information that this was declassified, there's still a bunch of declassified documents out there in his mind that really are still classified. And you can't retroactively do it. A former president can't say, but I really meant to put in the process to declassify these. Otherwise, every single president upon leaving office would be able to later say that he or she had done X, Y, and Z, including classification and declassification decisions, and ruin the entire national security classification system.
I also want to know, Jamie Gangel and others, including me, have talked to any number of former Trump officials, none of whom say that they ever heard some kind of blanket declassification, and many people use language to the effect that such a notion is absurd. David Priest, thank you so much for being with us this morning. Joining me, CNN legal analyst and criminal defense attorney Joey Jackson, and CNN legal analyst and former federal prosecutor Jennifer Rogers. Jen, let me start with you. Your take on this aspect of the ruling, no stay.
Yeah, well, this is a terrible opinion. I mean, DOJ gave her an off-ramp for this. They said, let's just talk about the 100 classified documents for which there is no legal justification for letting Trump have those back, no privileges, nothing. And she still said no. She said, you still have to stop. They put in a factual affidavit explaining the irreparable harm if they had to stop reviewing these documents. And there's no contrary facts. Judges are supposed to decide on the facts. The evidence is the affidavit. Trump's team's put in no affidavit. She doesn't really contest any facts in the government's affidavit, but just says, I'm not convinced. And at the end of her opinion, she tells us why. Because you have to consider the context, and the context here is it is the former president, and that governs everything for her.
In terms of the effect, though, Joey, what she does say is the only thing I'm saying you can't do is use the content of these classified documents. You can't read out loud these documents to witnesses that you question. You can't put the content of these documents before a grand jury. But you can put the fact that they exist before a grand jury. You can investigate how these documents got to a certain place. You can still talk to witnesses in general about the fact of the documents. So can't an investigation continue?
I don't think so. I think that it's very difficult to split hairs like that. When you're presenting anything to a grand jury, you want information. You want that information to be reliable. You want questions that grand jurors potentially have to be answered to the grand juror's satisfaction. Those are the ones who are actually issuing the indictment. But my only issue, with respect to disagreeing with Jen a bit, is that it's about trust for me in the government, right? I'm a defense attorney, okay? And as a defense attorney, I look to judges generally support the prosecution's point of view. What the prosecution wants, the prosecution gets. We beg for things in court. No, sit down, Mr. Jackson, thank you. Maybe tomorrow. I think it's about people really having a sense of value and belief in what their government is doing is true and accurate. You can't just take representations that a prosecutor gives you in court of what information is. What's the harm in having a neutral party sit, evaluate, issue a judgment that both sides agree upon? And I think it instills trust. A lot of people, believe it or not, do not agree and support what the government does. I think this pause, at the end of the day, whatever happens in this investigation, right, you're going to say you had a neutral third party evaluate, put it on pause. Now we can trust it. Let's resume and go again.
I detected a head nod there.
I mean, listen, it's based on nothing. That's the problem. You know, she has a legal analysis from DOJ as to why there is no legal basis for giving these documents to Trump. She has nothing from Trump. There's no legal analysis at all, and she doesn't provide any.
I get that.
There's no legal basis.
I get that.
You can't judge based on that.
But my only issue is that I just think at the end of the day, there's so much political spin on this, Jen. Everybody's out there. You know what? This is a political hit job on the president, et cetera. You get a special master. Both sides agree. You look at the documents, pause the investigation. There's no rush. And then
we'll see what Judge Dearie does also, because Judge Dearie's been told to prioritize the classified documents. Also, it actually could be a very quick process on those alone. You could see Judge Dearie saying, okay, go ahead, take them.
Except then what does Judge Cannon do? Because Trump teams come back and say, no, Judge Dearie got it wrong. Judge Cannon, help us fix this. But then what does she do? That's the problem.
Well, that's a fascinating question to consider going forward. Jennifer Rogers, Joey Jackson, thank you both for helping me understand this.